The Irish Times there this morning is reporting, or yesterday was reporting, about this house that was built in County Meath in 2006 without planning permission. There has been a 20-year legal battle over this house, and the end of the road has been reached apparently now, and the house must be demolished. So the couple have failed to stop the demolition of the County Meath home. It's a very impressive looking house. It's over 6,000 square feet apparently, which is a very, very big house, and it has been built in willful breach of planning laws almost 20 years ago. The couple originally applied for planning permission in 2006. Meath County Council refused them, but they went ahead and built a house anyway, and they built a house twice the size of the one that they had actually been refused. I'll stick a photograph of the house up on the video. It's an impressive house, there's no doubt about it. It's in Bohermeen, County Meath. It's been the subject of a protracted legal battle. The reporting in this case is from Mary Carolyn in the Irish Times. They have lost a last-ditch bid, legal bid, preventing the demolition of the County Meath home, which was built, quote, in willful breach of planning laws almost 20 years ago. The judge in this Court of Appeal judgment said that there was, quote, no merit to the appeals by Chris Murray and his wife Rose when giving the three-judge Court of Appeals judgment dismissing them. The appeals concerned an action that, while initiated in September 2022, was the latest battle in a 20-year war about the fate of the unauthorised development at Faughan Hill, Bohermeen, Navan. It was, he believed, obvious to Meath County Council from the outset that the action and appeal were artifices calculated to postpone the evil day, in other words, put off the demolition. After Mr. Murray's 2006 application for permission to build a house on the lands was refused, the couple, quote, undaunted and in willful breach of the planning laws, built a house anyway of about 6,220 square feet, which was twice the size of the house for which permission was refused, the judge said. The council then took legal proceedings in 2007 under the Planning Act, and in 2017, 10 years after that, the Supreme Court upheld High Court orders for the couple to remove any unauthorised development from their land, and they were given 1 year to vacate the property. That was in 2017. This is 8 years later, 2025. When that was not complied with, the council issued contempt proceedings in 2019 that settled in 2020 on terms involving the Murrays agreeing to vacate the property within 2 years to facilitate the council demolishing it. So that was 2020. Within 2 years then they were to vacate the property to allow Meath County Council to demolish the house. That was by 2022. 3 days then before they were to vacate, the Murrays issued a case against the council, claiming there was new evidence relating to land sterilisation agreements made by the previous owners of the land that invalidated the council's planning refusals. Last year, the High Court granted a council application to strike out that case as frivolous, vexatious and an abuse of process. In the Court of Appeal judgment on Tuesday, Mr. Justice Allen said that the couple built a 6,220 square feet house without planning permission, well knew they would need permission, but hoped that they would get away with it. The Murrays claimed, as a result of inactions and misrepresentations by the council, they had acquired a pig in a poke title to the lands, he said. While a planning condition for our nearby residents stated an agreement sterilising the lands from any other housing or non-agricultural development should be entered into, and the council relied on that in refusing permission to the Murrays, it was accepted no sterilisation agreement was ever entered. There was, quote, no justification for contending the council misrepresented the case to the court, he said. The Murrays had not appealed the original permission refusal to An Bord Pleanála or sought to judicially review it, he said. They had, quote, every opportunity to make whatever case they thought they had. The courts had considered all they had to say, but the Supreme Court had, in 2017, decided the house had to come down. While they argued in this appeal that adequate account was not taken of their new evidence, there was no appeal against the High Court conclusion it would not have affected the original outcome. At the heart of their opposition to the council's enforcement procedures was a grievance with the refusal of their original planning application, but as a matter of law, their grievance was not justiciable, that is, not capable of judicial ruling or determination. Any infirmity in the original refusal could not conceivably have provided any justification for unauthorised construction of a house, still less one twice the size, he said. It was perverse, he said, the judge in the Court of Appeal, that the Murrays, having driven a coach and four through the Planning Act, were complaining the council failed to strictly comply with the prescribed procedures. A so-called constitutional challenge concerning the council's use of section 160 of the Planning and Development Act 2000 in its proceedings was unrelated to the new evidence, he said. The couple's fresh permission retention applications were not relevant to whether their proceedings raised a fair issue to be tried, he held. The couple had not identified any error in the decision under appeal, the court concluded. So that is the decision. The Court of Appeal have given the go-ahead, the green light for Meath County Council to demolish this house of over 6,000 square feet, which was built in 2006 or thereabouts after planning application was refused. Hope you find the video useful.